Yes, Mr.
My lady, my lords, where I had reached was looking at the introduction of Section 12, as it was in the 1971 Act, and then the regulations. And I'd like to pick up there, if I may. The best place to look is in the witness statement of Helen Walker, page 21, paragraph 53, where she tracks the response that we saw to the Law Commission's paper and what the minister set out as the rationale for this section. So that's paragraph 53. As we looked at, what happened was a national insurance bill, rather than a bill focused on marriage as proposed by the Lord Chancellor, was made. In seeking committee's approval for introducing the national insurance bill on the 21st of April 1971, the then minister set out the rationale for this provision as follows. And we set out there the indented paragraph. And then over the page, there is a speaking note for the minister, which is exhibited. Yes.
Yes. The speaking note, do we know, what's the status of a speaking note from construction points of view? I mean, he didn't speak from it, did he? It doesn't say he did, just presumably 46, 47 is Hansard, is it?
Sorry, which is Hansard?
The previous little short passage
Yes.
you quoted is presumably from Hansard. I haven't checked, but it must be.
Yes. Let me just confirm. It is. Yeah. And the speaking note.
Well, a speaking note,
unless it was spoken in Parliament, of course, is not necessarily of weight. I understand the point.
it's not admissible, not necessarily of weight.
Let me just.
We can look at it de bene esse, but
if I may just check with those behind me as to whether this was, so far as we know, spoken in Hansard, and if not, we can obviously check. And forgive me for not having the answer immediately.
if we actually look at it,
my understanding is that so far as it's been elicited, I'm speaking to my learner Julie, who's saying that we will need to double check whether it was indeed reported in Hansard or not.
well, okay. I mean, you've all done wonderfully well, but I don't want to be too critical. But really, I'd have thought this could have been bottomed out. You know?
I appreciate that. I appreciate that, and we should have done that, and we will.
Okay. Well, we'll look at it de bene esse.
Thank you. May I just ask that you read the passage from paragraph 54, and we will confirm the exact status of the speaking note.
This speaking note, actually it doesn't take us much further, does it? Apart from saying regulating in rather than regulating out. Because the same point that has obviously caused some interest from members of the court is to the effect of asking how it is that it is delineated, certainly not by the text we see, in terms of a law recognising polygamous marriages. And we see in this speaking note that in the second paragraph, the effect of which is to confer on the Secretary of State power to make regulations defining the circumstances in which a marriage celebrated under a law which permits polygamy is to be treated as having the same consequences as one celebrated under a law which does not, which is English law. So, does this take us anywhere?
The part of it which we would say takes us somewhere is the last paragraph there. What we have in mind for the regulations is to cover those cases where a marriage that was once actually polygamous but is so no longer because the first wife died or parties came to this country, which echoes the first type of case that the Law Commission was concerned with. But other than that, I entirely appreciate that it's not addressed to the specific issue that your ladyship was asking about.
Or with which we are concerned.
Perhaps so. I think I need to be quite clear in terms of, by way of explanation, if not excuse. The starting place, as my lord will know, and my lady and my lord will know, the starting place for this argument it is a position which was, with no criticism to anybody, common ground at least below, and common ground previously in the case law. It's now come to the fore, understandably and rightly, on questioning from this court at the last hearing. And what we have tried to do with the resources at our disposal, but in difficult circumstances, is find as much material as we can to demonstrate what the understanding was of the policy intent and therefore the meaning of the words, insofar as relevant to the policy, to the meaning of the words, so that we can make submissions which seek to assist the court with what those words were meant to mean. I can't find anything more than what is here, and I can only.
If I appeared to be critical, I'm sorry, but you must not be oversensitive about this either.
No.
You've put all this material in front of us. Some of it may be of doubtful admissibility, but that really wasn't. I wasn't being difficult about that. We do need to know, especially where it's of doubtful admissibility, but anyway, actually how it fits in to the points you're making.
Yes.
So,
understand.
Okay. Well, that's
yes. Yes, indeed, and it may be that there isn't a great deal more that I can provide from this material other than what has been collected.
Well, we've got it. Thank you. I'm bound to say I agree with my lady. There isn't a great deal more than we got out of it. But where next? I mean, I don't mean where next. What's next? What's the next bit of material?
So she explains at 56. So the clause as drafted was approved by Cabinet Committee without dissent, and that's the section 12 that you have seen. Paragraph 56, she explains about regulating in rather than regulating out, and explains the background to that. Material specifically relating to section 12, to which I would draw the court's attention. Other than that, what's next then is the regulations themselves and what they mean and what thinking was done around that time in relation to those regulations. But I have to accept that the material that we found in relation to the regulations is also largely internal material. So it's the minute that I showed the court earlier on, which explains some issues around the regulations. But it's not a detailed explanatory memorandum or an explanation of that nature. So the regulations are, so section 12 we have seen. The regulations that were initially made were the 1972 regulations. And before we turn those up, I'll just show the court the material that we have found in relation to those regulations, which starts at paragraph 61 of Ms. Walker's witness statement. She explains the context for the 1972 regulations in the policy note to which I just referred, which is the note at tab 2, and she sets out an excerpt from that there. What that is largely concerned with is whether it's appropriate to impose some form of residence or presence test within the regulations, which, as far as I can see, didn't actually occur. But perhaps if I just let the court read that passage.
Yep.
And I needn't trouble the court at this point with any of the further detail. What we then have is the regulations themselves, and perhaps the best place to start is just to go to those and look at those.
So when we're reading the statement, it would be better for us to go to paragraph 61 before going back to 60. Is that what you're saying, or
Yes, what I was
59?
what I was trying to do was to show, yes, it would.
Yeah.
What I was trying to show was to show that the 72 regulations were made, and they're then in identical
Yes,
form.
it's just for the note so that we know
sorry,
where
Mary.
to read. So if we go to paragraph 61 and then go back in the statement to paragraph 59.
Correct. Those, yes,
Are you about to take us
to the regulations.
so that you're taking us to the 75 regulations?
Well, the 72 regulations are in identical form to the
Quite.
75 regulations.
It doesn't obviously matter which we
No.
look at, but
And we
since it's 75 regs we're concerned with, presumably that's where we're going to go.
Those. And what we could do is just look at them here in that passage if it's easier.
Okay,
Yes.
whatever suits.
I mean, it was
Yeah.
just so that the court was aware that they were initially made in 2 form under section 12.
And then when
Those-
they're remade in 1975,
75.
by that time there's a difference.
Under section 162.
Okay.
And in order to short circuit it, maybe we just go straight to the 1975 regulations, and we can look at them here, or we can look at them in
Well,
the.
speaking for myself, but we got this open. I might sort of from here,
Yes.
but well, sorry,
So-
sorry to be inconsistent. Actually, I've already started to mark them up in the authorities. So
Yes.
speaking for myself, I
So
will go
it's-
there.
It's in the original authorities bundle
Yeah.
at tab 3. So we see the definition section of Regulation 1.
Out of curiosity, this isn't actually the Queen's Printer's version, is it? But I'm sure it's right. Because it's all sorts of, the capitalisation has gone funny in various respects.
Yes,
I'm sure the text is fine.
I think it is. I'm not sure.
Well, there's no doubt it's all to do with it being back historically. Yep.
So we have Regulation 1, and we've seen the definition under subsection 2 of polygamous marriage, meaning a marriage celebrated under a law which, as it applies to the particular ceremony and to the parties thereto, permits polygamy. Now, when we were looking earlier at the ceremony, the law of celebration, and personal law, the law of validity, if I can put it like that, in my submission, the word polygamous marriage there is defined as including both celebrated under a law which, as it applies to the particular ceremony and to the parties thereto, permits polygamy. So that may import into it the question of the validity itself, as in personal law as well as the law of celebration.
Yes, but it also still leaves the question with respect to Mr. Leventhal, if a law, in this case the law of Pakistan, recognises both by virtue of the place of celebration that a polygamous marriage is a possibility, but also does not disallow a person with a different domicile from entering into that marriage, that could also be encompassed within these words.
It could, but it would be a question for the English court adjudicating on the question to determine whether indeed it was or was not a polygamous marriage permitted.
Under a law, which could be Pakistani law.
Yes, and we had a think about this over the adjournment. There is some assistance on this point in the case of Lee and Lau, which, albeit predates these provisions from 1967, what that basically says in a nutshell, and I'll take the court to it, is that it's for the court, for the English court, for the English legal system to determine whether the law permits polygamy or doesn't, and whether the marriage is therefore properly to be decided as polygamous or not polygamous.
So to determine whether or not the law of Pakistan would recognise this marriage as a valid marriage.
Or whether the law of Pakistan is indeed a law which permits polygamy or not.
Yeah.
I have in mind the Hong Kong example there, where there was a law which permitted concubines, but was held by the law of England, I'm sure my lady's familiar
Yes.
with it, to be polygamous, to be treated as a polygamous marriage for the purposes of English matrimonial law.
I don't know where it's taking you though, because if it's for the English court to determine whether the law of Pakistan would recognise the marriage of Mr. and Mrs. Akhtar II,
Yes,
Mrs. Beebe,
yes.
then that would be determined by the law of Pakistan, not the law of the UK. If it was determining the validity of the marriage by virtue of the application of UK law, then the fact of the celebration being recognised is not going to save the marriage, as you've pointed out.
Yes.
But we go back again, polygamous marriage means a marriage celebrated under a law, which is it applies to the particular ceremony and to the parties. So if, is it your submission that if the determination of the English courts was, at the time that Mr. Akhtar married Mrs. Akhtar II, that regardless of the domicile that he carried with him, they would recognise polygamy, then that falls within this definition.
I think the answer to that question is no, if I properly understood it.
Well, then you're going to have to distinguish Lee and Lau, aren't you?
Perhaps so. May I ask, I'm sorry if I seem dim, but may I ask my lady to ask the question again, just so I can be absolutely sure that I've understood?
No, it's me, not you. If we are considering, as you say we must, that this definition requires an English court to determine whether the law of Pakistan, keeping it to the facts of this case,
Yes.
would recognise as valid the marriage that was in fact celebrated in Pakistan, regardless of the fact that Mr. Akhtar was domiciled in the UK, if the answer that the court arrived at was yes, it would be recognised in Pakistan as a valid marriage, that would then appear to be covered by this definition in section 1 subsection 2 of the regulation. And that accords with Lee and Lau. And I'm sure I put it very clumsily both times.
No,
but
not at all. It's probably the benefit of many is family law experience rather than my best shot of trying to understand exactly what happens here. And forgive me if I'm not as up to speed on it as I should be. I suspect then that Lee and Lau is probably a point against me rather than a point for me on that analysis. What
we'll come to it in due course.
Yes, let's wait because
Perhaps
for
so.
those of us who have not only no years of family law experience but haven't read Lee and Lau, I think I'll find the debate easier when we get there.
Indeed.
But just to go back to the substance of of my lady's point.
Yes.
If I were a judge in Pakistan and a marriage was properly performed under Pakistani law, which, subject to the point I'm about to come to, permits polygamy, would I be interested in the domicile of the people who had celebrated the marriage in Pakistan?
Well, you may or may not be, depending on what the law of Pakistan said about validity.
But does
and
English law, when considering the validity of a marriage in this country, English law worry about domicile? It doesn't come in, does it? If I go round to the registry office and marry someone, the only law that will matter will be English law for all purposes. Whether I have come to the country the day before or have lived here for 50 years.
But if the law says under Section 11D, or for that matter Section 11B, that you can't marry a second time, and that if you purport to do so, it's void, then English law does care about domicile in that sense.
Yes, I see. Okay, I need to think it through, but yes, thank you.
I understand the point, yes.
Sorry, I have a question too about this. It's the expression, a marriage celebrated under the law. As we've discussed today, there's a difference between the place of celebration and formal validity, which includes capacity.
Yes.
So, under what law is a marriage celebrated? Do you submit?
Under Pakistani law in this case. The law of celebration.
The law of so the expression marriage celebrated under a law must be the law applicable to the formal elements of the ceremony. So what this is referring to is and only is the law of the place of celebration.
Well, subject to the parties there too means, whether it means anything different. But I think I've probably gone down that rabbit warren and haven't reappeared.
But it only permits polygamy. So it's got to be that the law of the place of celebration, as it applies to the particular ceremony and as it applies to the parties, permits polygamy. Because if it didn't permit polygamy, you probably wouldn't be here at all.
No, quite.
Either because it's not a marriage that's valid by the law of the place of celebration, or perhaps for some other reason.
Yes.
So, I mean, you don't have to agree with this, but do you agree that we are here talking about one law, sorry to repeat myself, being the law of the place of celebration?
That's that paragraph, that subsection is referring to.
Right.
Yes.
Thank you.
And then we have the definition of monogamous marriage, which is celebrated under a law which does not permit polygamy. And then we have the definition of, in fact, monogamous, to be construed in accordance with Regulation 2.2 below. And so, Regulation 2.2 over the page, or Regulation 2.1 I should start with, subject to the following provisions: a polygamous marriage shall, for the purposes of the Social Security Act and the Family Allowances Act, and any amendment construed as one of these acts, be treated as having the same consequences as a monogamous marriage, but for only any day throughout which the polygamous marriage is in fact monogamous. And a marriage marriage is in fact monogamous to little a, when neither party to it has any spouse addition to the other, so there is only one spouse remaining in existence. And then we have subsection B in relation to the day on which a marriage is contracted or on which it terminates, be treated as a day throughout which it was in fact monogamous, if at all times on that day, and so on.
Yes, but it goes on more specifically. If at all times on that day after it was contracted, or, as the case may be, before it terminated, it was in fact monogamous.
Yes.
So it's talking about there, is it not, the duration of the marriage, using the word terminated rather than determined, but it's talking about, as I say, the duration of the marriage.
Yes.
So for any day on which it was actually monogamous during its duration,
Yes.
it's to be treated as
Day on which it was in fact monogamous.
treated as monogamous. Yes.
Yes. For that day. So, for example, I think, if it were in fact polygamous, there were two life spouses for a period of time, and then for the 3 months prior to the claim for benefit and the bereavement, the death of the partner, the earlier spouse had died, you would then have a period during which, after it's contracted and before its termination, it was in fact monogamous. That's my understanding of how
It's just
the provision
it's simply a
works.
calculation provision to cope with
Yes.
the question why, if a particular day is crucial, as it may be for a time limit,
Yes.
does it count if it's the very day on which the previous spouse died?
Yes. And for present purposes, it isn't such a fine distinction. We have a period of time after which Mrs. Beebe died and Mrs. Akhtar was Mr. Akhtar's only live spouse, in the sense of whether it is or isn't. It was only the only live wife that he had for that period of time. If to bring herself within the provision of polygamous marriage, then it would apply to her. But we say that it is not a polygamous marriage which can be taken account of because it's not a valid one. So that's where we get to the reading in of the words, a valid polygamous marriage.
The necessary implication.
Yes.
So the regulations read independently would encompass a person in the position of the claimant in this case.
If her marriage is, yes, if her marriage is treated as not void. And that's, as I understand it, common ground. Certainly from our perspective. So the issue is whether you read in the necessary implication or you don't. Or that you treat it as including that necessary implication.
But you see, if we go, and this is based on, I mean, we can take section 12, can we, as a fair formulation. Because it uses the same terminology, doesn't it? It uses the terminology a marriage celebrated under a law.
It does.
And it would have to, because it's the empowering, it's the enabling provision.
Yes. And subject to anything, I think I would want to come back on Lee and Lau. The arguments are, as we've already rehearsed, as it were. So, you either treat the words as being a marriage celebrated under a law which permits polygamy, or a valid marriage celebrated under a law which permits polygamy.
And the valid relates to the UK section of it rather than the country of celebration.
Correct.
Well, quite. That's why the words have to be otherwise valid under English law.
Yes. And I use valid as a shorthand, but you're absolutely right for the reasons that we've already rehearsed, that it would need to be otherwise valid under English law. Not just valid, not valid under the law of under the place of celebration, for the reasons my lady has articulated. Put to me.
So the regulations, if they apply in the circumstances of this case, are easily understandable. For any day on which the marriage was actually monogamous is a day in respect of which benefit can be calculated and payable.
Subject to it triggering the relevant entitlements and so on, yes.
So
I mean, it's no good to have a day earlier on in the process if you then additional, it's not in fact monogamous at the time of the claim for benefit.
So that would apply in this case in respect of bereavement, because it was monogamous at the date of her spouse's death.
Yes.
And insofar as the calculation of widow's payment depends on contributions, it would also be easily calculable because everybody knows for what period it was an in fact monogamous marriage.
Yes, because we know the date of death of the first wife.
So in terms of application, it wouldn't cause any difficulties.
Not that I'm aware of, unless anyone's jumping up and down otherwise, but no, not that I'm aware of.
And is that true in more generally, if one looks at other situations in which it might be applicable?
Well, this is where we come on to the Commissioner's material, which is the next set of material to come on to. Because in those cases you see that actually, although in this particular case one can see that if you treat the polygamous marriage as valid because of its validity under English law or otherwise, if you treat it as included within this, the situation may be obvious because Mrs. BB is no longer with us and Mrs. Akhtar is. But actually, the situations that the commissioners are having to grapple with is a situation where you may have two live spouses, one or both of whom is making the claim, and domicile and validity serve to identify who is purporting to marry whom at which time, hence where we are. Otherwise you would just cut out all of that and either disallow the benefit for both or either, depending on the circumstances. So although it's through the prism of this case, one can see how it would apply, through the more complex prism of the full gamut of cases, there are actually quite a lot of difficulties that the commissioners and subsequently the Upper Tribunal have had to grapple with.
Are you saying that some people would be excluded who otherwise would now be included?
Yes, because, and I'll take you.
Well, would it make sense for us, and I don't want to stop my
Yes.
lord pursuing his line of questioning, but I think it'd be easier for you and probably easier for us as well if we go to that next section, which is looking at the Commissioner's decisions.
Yes, agreed. And I will want to come back to Hussein and Hussein in section 11D, because that was a final point I needed to address, but I'll put that to come back to.
Thank you, sorry. Yep.
No, thank you, my lord. So, there are 5 relevant decisions, and I think I can select the 3 most relevant because 2 of them pretty much say the same as one of the others, and so, and they're by the same judge. So I think it's easiest to see it in that context. If we start with Mrs. Walker's bundle, has those decisions in it, and it's tab 18. The first decision that I showed the court was the 1952 decision. This one is a 1993 decision, tab 18. So it postdates the relevant regulations and the law as we now know it, insofar as applies to our circumstances. And it's a decision of Mr. M. Johnson in the Social Security Commissioners that's now become the Upper Tribunal Administrative Appeals Chamber. There were 2 wives claiming here, and the issue was domicile and whether one of the marriages, whether the second marriage was invalid. So if I can ask you, the court, just to read the summary of the facts, please. So, but both claims had been disallowed at the original stage. And then if we turn into the situation at the judgment at paragraph 7, we see a summary of the principles originally elicited from the G case, the 52 case, and then subsequently the 1970 case, which I haven't turned up. But the principle is encapsulated there. It is therefore well settled in trite law that for social security purposes a widow is only entitled to widow's benefit if at the date of her husband's death, in addition to his having necessary contribution record, their marriage was in fact monogamous. That means that at that date there must be no other valid and subsisting marriage. Where a husband's entered into another marriage or purported marriage in order for his marriage to the first wife to be monogamous at the date of his death, it will have to be shown among other possibilities that the second wife was dead, the second marriage had been validly dissolved, or in the instant case, it was invalid at the date it was celebrated. And that was what the tribunal had not investigated. And so at paragraph 10, the Commissioner says, in my view, the question of domicile is crucial to this case, and it's the tribunal's failure to consider that matter which renders its decision erroneous. So that he then sets that aside and goes on to consider the matter afresh for himself. And at paragraph 16, he applies the law of his understanding of the law on domicile and validity to the facts of this case, and finds that as the date of his marriage on 19th of May 1981, Mr. PD considered himself and in fact was subject to the distinctive legal system of Bangladesh, and his marriage to Mrs. A.D. must therefore be considered a valid and subsisting one in English law. So in other words, he effectively was domiciled there, he remained domiciled there, and so had in fact entered 2 valid marriages in Bangladesh. Extremely unfortunate for Mrs. J.D. Had I been able to find that he had retained his English domicile of choice at the time of his marriage to her, then that marriage would be invalid and Mrs. J.D. would be the only lawful wife. So the Commissioner's reading of the legislation is in line with, or rather, it's the interpretation which we put before the court.
So it's just in para 17, which I was just looking at. I see.
Yes.
Could I ask?
Yep, I see that.
This situation wouldn't be covered by the regulations because, in fact, there was not an in fact monogamous marriage.
That's right. So it determines whether or not it's in fact monogamous. If there are 2 wives, then it's not.
Yes, but the difficulty in our case is that there is only 1 wife. So this is very interesting, but this would not fall under the regulations, whether the marriages were valid or not, according to a law. It doesn't, as it were, fulfil the criteria that at the time of the claim, only one, it is in fact monogamous.
Yes.
This could never have been monogamous, could it?
Well,
Given the finding of domicile.
Given the finding of domicile, but that begs the question, what purpose the finding of domicile serves.
Want to know whether or not there are more than one wife?
Well, quite, but I accept that, indeed. What I meant was, if you are, on the facts of this particular case, you have two wives who are still alive and who are, it was found, both married validly under Bangladesh law. If you'd had the subsequent wife married validly or invalidly, as it were, under English law, then the first wife on this analysis would have been entitled, because it would then have been monogamous. So I appreciate it's not the same facts of this case, but I'm trying to show how the law of domicile is, as it were, superimposed onto the regulations to decide whether in fact monogamous incorporates a subsequent valid or invalid marriage.
Right.
So that's the first decision. I think the second decision is the decision of Commissioner Howell, and that's at tab 19.
So I just was noting down your previous submission. It shows how the law of domicile is superimposed onto the, what did you remember what you said?
Question of, I can't, but question of validity of the marriage, and question of whether there exists more than one marriage for the purposes of asking whether a marriage is in fact monogamous or not.
Thank you.
And in that decision G that you've just taken us to, did the Commissioner have to grapple with the regulations? And the particular issue of recognition under A law?
It doesn't appear from the decision.
No.
He doesn't cite them or refer to them.
No, thank you.
Tab 19 does cite the regulations, and Commissioner Howell, now this was a case with 3 potential wives, all marriages taking place in Bangladesh over a period of time. And it was the second wife who made the claim. Paragraph 3, I'm afraid to say that the facts in these cases are always slightly complicated for obvious reasons, but paragraph 3, if I can just ask the court to read paragraph 3, that might help. So, paragraph 6 encapsulates the regulations and the point which the Commissioner finds arises. A person seeking to claim widow's benefit under the 1992 Act has to be either the surviving member of a monogamous marriage, recognised as valid, or the surviving member of a valid marriage under a law which permits polygamy, but in fact the only spouse of the deceased at the date of his death. So we see there a reference to, as it were, the necessary implication words of valid marriage. And Regulation 2 of the Social Security Regulations is cited there. Consequently, on the footing that the deceased had, as a sexual status considered consistently accepted and argued, retained his domicile of origin until he died there in July 2000, and there being no doubt of dispute as to the validity under Bangladeshi law of his 2 subsisting marriages, to Mrs. F.B. and Mrs. J.B., who both survived him, the claim for widow's benefit by Mrs. FB had to be rejected as she was not the deceased only wife. So it's again another example of there not being in fact a monogamous marriage, but the principle of validity is nonetheless considered there. And paragraph 9.
Well, it does, but it says a valid marriage under a law which permits polygamy.
Yes. But
It doesn't say a valid marriage under a marriage valid under English law and celebrated under a law which permits polygamy.
No, but if you go on to paragraph
Sorry,
8,
it just yeah.
Sorry, my lord, you're quite right. That is what it says.
That is what it says. Yeah.
At paragraph 8, the Commissioner says if the finding of an acquired UK domicile of choice by that date was indeed correct, the first marriage to Mrs. A.B., who came into the country as Mr. A's wife the following year, was still then subsisting, then it would have to follow that the second marriage was to Mrs. F.B. was void by the law of Mr. A's domicile. And the appeal should have been rejected on that ground, however, the stated reasons, and so on. So,
could you just explain that? Why
yes.
would the appeal have to be rejected on that ground?
Because Mrs. F.B. would then not be married to him at all.
Essentially because you also, Mr. Howell, has accepted as self-evident your point.
Yes,
So FB is the claimant.
correct.
Yeah, thank you.
But didn't he marry FB in the United Kingdom?
I thought that he married her in Bangladesh.
Well, if you look at the bottom at page 1 of paragraph 3, according to the findings of the tribunal, her late husband, Mr. A, lived in the UK for about 8 years before their marriage in April.
Yes, if you go up, my lady, at paragraph 2, it explains the second marriage took place in Bangladesh on the 22nd of April 1968.
Yes, I see that now.
So yes, so it took place in Bangladesh.
I see, yeah.
And so what the tribunal was trying to do was to investigate, basically, whether in fact he was domiciled in the UK at the time of the second marriage, or only by the time of the third. If it was only by the time of the third, then the second marriage was valid and the third marriage void. So domicile would have therefore given rise to an entitlement.
According to English law.
Yes, according to English law. Then Mrs. F.B. would have won, effectively, because she would have been the first wife having died,
Yes.
the second wife having married.
She was the second wife.
She was the second wife, sorry, yes, she was the second wife, and the third marriage would have been void.
Yes.
So it would have been.
Would have been void as English law.
Yes, in fact, monogamous.
It still doesn't grapple with the point, though, does it? Of the automatic assumption that the it is not dealing with what it means to say under a law that recognises a polygamous marriage.
Perhaps not directly in that respect, but what it does do is say, if you're entering into a marriage at a time when you're domiciled in the UK, you can't validly enter into a polygamous marriage.
Well, we know
Potentially there are
that.
others.
We know that, but that's not the point. It's whether or not the regulations are referring to a recognition beyond domestic law. And
That's right.
my Lord's questions have been pointing to that with respect.
Yes.
In the sense that we're not just talking without those explicit words being present necessarily, although necessary implication comes into it. I know you
Yes.
say that.
Yes.
But if we read this in its simple, straightforward sense, it would cover a situation, as here, where a polygamous marriage has become monogamous by the death of the first wife, and the polygamous marriage would not be recognised as valid under English law because of domicile of the husband, but would be recognised, if the English court so found that to be the case, under a law under which the marriage was celebrated, namely the law of Pakistan.
Yes.
And I don't know that this Commissioner's decision is going to let you, as it were, escape that again.
No, perhaps not.
But perhaps I'm being slow. It's completely consistent with your analysis.
It
The
is.
only thing that can be said about it is that Mr. Howell does not explain, or does not. It's because he assumes your analysis to be correct rather than explains how it's correct.
Yes, correct. Because if that's right, if it was as simple as the way in which my lady put it to me, domicile would be irrelevant. He would simply say, how many marriages were there subsisting at the time of the death? More than one, you don't get your benefit. Sorry, I don't mean to be flippant. I'm just trying to be clear.
Yes.
More than one, you don't get your benefit. Only one, you do. That is the simplicity that is in the alternative construction. But unfortunately, it's not.
This is it's partly because it's not relevant to his decision.
Well, it is. It's not relevant in the same direct way as it is here, but it is relevant because of the third marriage. So he's trying to find a way to allow the second wife's marriage to be the only valid subsisting marriage at the date of the death. But he can't do that because of the law of domicile.
Well, that's slightly different.
It is.
And as my Lord Justice Underhill says, it's making an assumption rather than giving an explanation. And that assumption obviously has been made by commissioners, as you're going to show us in the other three cases that you've got.
Yes.
But it's not necessarily a right assumption. And this then goes into what you say is an aid of
We may
construction.
be making too much of a meal of this. I mean, I don't think you're saying that certainly the ones that they, as it were, reason through to the conclusion, or it's a necessary part of their ratio. So if we were bound by it, we'd be bound by it.
Yes.
But it's not explained.
No.
So it's of no value to us in terms of giving us an intellectual explanation of why his assumption is correct, and you're not suggesting it is. I think you're showing us these cases for one reason and possibly two. One reason is to illustrate the kinds of problems or kinds of situations that might arise if the law were not as you say it was. You haven't quite spelled that out yet and why it would be a bad thing, but I mean,
Correct.
it's to illustrate the difficulties.
Yes.
And the other reason is if you are going as part of your aid as one of your aids to construction.
Settled practice.
But you're not attempting to show us this to show now this explains why I'm right. It doesn't. It just shows that
the
previous people have assumed you were right.
Yes, and indeed, yes. It's correct. Those are both the reasons why I am showing you it. And I agree that it doesn't reason out the assumption, but it does make the assumption, or rather it proceeds on the assumption that we submit, is the necessary implication.
Yes. It helps you a little bit because here are two distinguished lawyers to whom it seems self-evident, but it doesn't take you very far.
Well, I just wonder, if my Lord will forgive me, the two cases you've taken us to at the moment were not in fact monogamous.
Correct. Not in fact monogamous because there were more than one wife alive.
So under the regulations, however you read them, whether strictly or not, they would not have been entitled to benefit.
On the reading.
On the basis that there's more than one wife. And the regulations provide that it's got to be actually monogamous, even if it was polygamous in fact.
That's correct.
So these two that you've shown us, there was more than one potential applicant.
Well, not if the marriage was invalid.
Well,
not if the other marriage was invalid.
well,
There
I think
were in
that's-
existence a number of potential wives. if we use...
They're all alive,
There-
that's a
those-
difference.
the relevant- there
But
was
they're
more
not all
than one
necessarily
alive.
wives.
There was more than one alive. That is the relevant difference. And so I understand it's a question of whether validity comes into it at the threshold or never. But if it comes into it in determining which marriage is valid and when, then it is relevant, because albeit neither of them were in fact monogamous, that begs the question, if he could have read it in the way that I say he should have read it and did read it, then if he'd found either of the relevant marriages to be void under English law, one of the beneficiaries would have benefited. And that's the point.
Yes, the point about validity came in at a different stage of the argument, but it was nevertheless came in and was determined by applying the domestic law of validity.
And obviously the question for this court is whether that was right or wrong.
Yes, right.
And I accept that. I accept that what I'm doing is showing you, albeit late in the day, the settled practice which started this upper tribunal on the road that we've now find ourselves on.
Have you got any cases that actually would grapple with the situation that we have, which is where there is only one wife alive, and the validity of the marriage is nevertheless suspect? So we've not got a commissioner trying to do their best for a widow, or a widower it could be, whose spouse happens to have made all of these contributions to the national insurance scheme, rather than where you could say, well, whatever the decisions as to domicile, you could actually move on straight away to saying, well, there's more than one wife. So whether it's validity under the law of celebration, or country of celebration, or personal law, it would not apply. So is there anything in the Commissioner's reports where we get something more similar to the one we've got?
I think the most similar one, and I will ensure that I haven't missed any out, I was going to skip over 3 and 4 because I think they are more of the same, and take you to number 5, which I think is the closest we have. And that's at tab 21, and that was the one which the Upper Tribunal Judge Whiteley in this case referred to as helping us on it. So it's tab 21, page HW 438.
And it was his own judgment, not being modest or anything.
No. Always the best way, relying on your own. They're perhaps the ones that stick in the memory more than others, I don't know. So, the facts of this case, we see paragraph 10.
Sorry, paragraph.
10.
Thank you.
And on page 441. So there was only one live, sorry, it sounds it doesn't sound particularly pleasant. There's only one live wife still alive at the date of claim. So paragraph 10, we see Mr. S originally marries, shall I just let you look at it? It's probably not helpful if I speak over it. Look at paragraph 10, please. And then at paragraph 14, Upper Tribunal Judge Whiteley sets out section 11D and then the relevant regulations. So he sets out section 11D in terms of the validity of the potentially polygamous or polygamous marriage. And at paragraph 16, it refers to the fact that Mr. S's second marriage was valid under Islamic law and the law of Bangladesh. However, by virtue of section 11D, it follows that if at the time of his second marriage, Mr. S was domiciled in the UK, then under the law of England and Wales, he had no capacity to marry Mrs. N. So while valid by local law, the marriage would be void under English and Welsh law at its inception, because he did have a spouse additional to the other. then he goes on to look at the regulations at paragraph 17 and picks it up at 19. Regulation 2, he says, he sets it out and he says, however, this doesn't have the effect of converting a void marriage into a valid one simply by virtue of the parties being in practice monogamously married immediately prior to the party's death. Instead, it means that a valid polygamous marriage can be treated as a monogamous marriage, so on. And then he cites Mr. Howell's decision, which we've seen, and the question of validity, to which I referred you, and looks at validity in the same way, but on those different facts. And then he goes on at paragraph 20 to look at the question of a valid marriage. And perhaps if I just ask you to read paragraph 20.
Is the G case that's referred to in paragraph 20 the one that you took us to
No.
right at the start?
No, that's the 1952 decision. The 1959 decision is not the one I took you to. Let me find, if I may, where we've got it in the bundles, because I haven't got that to my
Thank you.
fingertips.
But you told us, I think, that following the 52 decision, there were 3 or 4 to a similar effect.
Yes.
This is presumably one of those.
It is, albeit I think it's on whether a marriage existed at all, and I'm not necessarily sure.
Okay,
it's on
yeah,
whether-
I'm not stopping you
whether
taking
check.
this. I'm just seeing how it fits in.
Thank
Yeah.
you, yes. So what he effectively found in a nutshell was that there wasn't a proper investigation of domicile by the first tier tribunal, and that therefore it all turned on whether or not Mr. S was domiciled in the UK in 1983 or not. Now, on my analysis of the regulations, that is the same issue as here, and we have an acceptance that Mr. Akhtar was domiciled here at the time of the relevant marriage, and therefore the relevant marriage to Mrs. Akhtar is void under English law. But in that case, that issue had to be determined, and therefore it was remitted back. So it's the same, effectively the same approach applying to different facts and carrying through from it the finding of validity or the reference to validity that we've seen in the origin of Commissioner Howell's decision.
Okay, well,
In answer to my lady's question, I think that's the clearest encapsulation of the principle, and that's as far as it goes.
Yeah, and I think that's it. That's as far as it goes, because it's always talking about validity according to English law. Could I ask a question? And I don't expect you to be able to answer this, and it could be that I should know it already. In this case, Mr. Akhtar pronounced a talaq, and he pronounced it in the UK, which was not effective for the purpose of the UK recognition of a divorce or an annulment. Was it recognised in Pakistan? And the reason I ask that is because if it was, and subsequently Mr. Akhtar went to Pakistan and married, it would be effectively his only marriage, which was potentially polygamous.
Because it was entered into a law that... yes.
So far as
Yes.
Pakistan was concerned. I know
Yes.
that it wouldn't alter the position here, but it's a further layer of onion skin, I suppose. Perhaps it's irrelevant, but it's just...
We will
take it through.
Off the top of my head, I don't know the answer, but perhaps we can take that away and
And
try
it-
and provide you with an answer.
I only ask that because it then puts it into context when we look at these other decisions that you've taken us to, as to whether or not there are 6 wives or 2 wives, and how many are still existing validly under any law.
Yes. So, what we say is, in circumstances where either in the more than one wife situation there is only one valid marriage under English law, it may be that that affects the entitlement, in answer to my Lord's question about whether this could have implications the other way. And secondly, we rely on this line of decisions as representing a settled practice. And we do that on the basis of 2 propositions. Firstly, that this court has recognised the particular technical expertise of the Social Security Commissioners and the Upper Tribunal in a number of cases. And that's authority for that proposition in the case of Cook. And we've cited that in our skeleton argument at paragraph 64. And secondly, so we have a specialist jurisdiction who deal regularly with domicile and issues of benefits law, and have, we say, applied this approach, the necessary implication, as it were, of validity under English law overlaid upon it, and that is worthy of respect by this court. That's the first point. And the second point is, can a settled practice ever be an aid to construction? In other words, can the court's got to ask its question itself. The question is that right or wrong? Should we respect it or not? And I rely on the speech of Lord Carnworth in the case of N in the Supreme Court, which we've set out in our skeleton at paragraph 6. Lord Carnworth, perhaps if I just ask you to look at the skeleton, you'll see the point I'm making. The case of N, I call it N, it's ZH and CN, N Borough of Newham, 2014, USC. At paragraph 95, Lord Carnworth referred to the fact that settled practice may, in appropriate circumstances, be a legitimate aid to statutory interpretation, where the statute is ambiguous but has been subject of authoritative interpretation in the lower courts, and so on, where businesses or activities, public or private, have reasonably been ordered on that basis for a significant period, there should be a strong presumption against overturning that settled practice in the higher courts. That should not...
Does the fact that there have been quite a lot of cases show that, in fact, it hasn't been operating without serious problems or injustice?
I'm not sure, I mean, I take the point, but I'm not sure that we can necessarily draw anything out of the number of cases, because it may be that...
That's their comment.
And it shouldn't necessarily, that principle shouldn't necessarily depend on the degree of frequency of parliamentary interventions in the field. So it's not simply where Parliament intervenes, and one can be taken to assume that Parliament was intervening against that settled construction. It can also apply outside of that. So I appreciate that point was an additional reason that Lord Carnworth decided the appeal in that case. But Lord, just for the court's note, Lord Hodge at paragraph 53, giving the leading judgment in that case, also approved it in the case of ambiguity as an additional reason. So it does have some support from another member of the Supreme Court. So we say, drawing those 2 strands together, you have a series of cases in a specialist jurisdiction, which we say go with the wider context of the legislation as it was introduced in the 70s, and that therefore that can legitimately be used by this court as an aid to interpretation. So that's my point on settled practice. It's a short one, really. I'm conscious of the time. What I propose to do is just deal with one final point about Section 11D in Hussain's.
So far as time is concerned, we had a discussion over the short adjournment. We are still hopeful that this case will finish within the estimate. You should certainly strive to achieve that. You're doing most of the heavy lifting, so Ms. Rooney will, I'm sure, be a lot shorter. But we will not regard 1 o'clock tomorrow as an absolute deadline. We might be able to go on a little into the afternoon. Don't take that as an encouragement, but I just don't want you to not make a point you want to make because you feel you've got to stop by 3:30 or something.
Yes, indeed. Thank you, my lord. I'm very grateful. I have actually, believe it or not, made pretty much all the points I want to make on the construction issue, subject to this one point. And then
Is this coming back to the Hussain point?
Yes.
Yeah.
And then my points on Article 14, for the reasons that my lord already indicated, will be much
Good.
briefer.
Okay, well, let's
So I shall crack on. So the final point I wanted to make is an additional point about whether or not it would have been in the contemplation of Parliament at the time that it was introducing the 1975-1972 regulations, as they first were, as to whether a person domiciled here could have ever lawfully entered into a marriage which was potentially polygamous, which is the Hussain and Hussain point. Now, we've been through the 1971 report to that effect, that a marriage to that effect would be void. But this was a point that was then picked up subsequently under Section 11D and in Hussain and Hussain. And I can, to make the point, hopefully, relatively crisply, I can take the court to Ms. Walker's witness statement at paragraph 21 and just show you the point as it's made there. Now, do you remember I showed the court the amendment to the 1971 Nullity Act that was made by Section 4 of the 1972 Act? Mrs. Walker picks that up here. That was to address the question of, which then became Section 11D. If you look at paragraph 22, this is the form in which that provision was originally found, with the underlining showing the relevant words. We saw it in its original form in Section 1. Sorry, Section 4, which amended Section 1. The point there was that Section 1D referred to a polygamous marriage, and for the purposes of paragraph D, this is the definition, a marriage may be polygamous, although at its inception neither party has any spouse additional to another. So at that point in time, and pursuant to the Law Commission's recommendation, with no change intended to validity, the intention was that a person couldn't even enter into a potentially polygamous marriage, even if at that time it was only potentially and not actually polygamous. That was what the intention, or albeit the Law Commission considered its intention was. And as she goes on to explain, the wrinkle that occurred in the Hussain and Hussain decision, subsequently in the 80s, post-dating the regulations, was not one that had necessarily been anticipated by either the Law Commission or Parliament in having made that change. As she explains, the 1971 Law Commission report did not recommend a change in the law relating to capacity, as we've seen, nor further was the passing of the 1972 Act understood by those promoting it to effect any such change. And then she cites the Law Commission's working paper of 1982, which addressed it. There was no debate on the bill, there was no extended discussion of the relevant clause. Here's from the report of the committee. The clause was introduced because of the rest of the law of nullity had recently been codified, and its inclusion was intended merely to embody in statutory form the observation from the observation from our report. And so what Section 4 was intended to achieve, or was understood to achieve, was that principle. Under English internal law, no one domiciled in England and Wales had capacity to enter into a polygamous marriage, even if the marriage was only potentially of that nature. It was only in the later decision of Hussein and Hussein that the Court of Appeal disagreed with that. Now, without getting into the detail of Hussein and Hussein for present purposes, we've summarised it there, and it's in the supplementary tab 20 of the authorities. What the upshot of that is was a subsequent amendment in light of Hussein and Hussein to what we now see as Section 11D, so that only an actually polygamous, not a potentially polygamous marriage is void. But if the court turns over to paragraph 29, you'll see that section's set out there in the way that it was changed to reflect what the court found in Hussein and Hussein and the subsequent work of the Law Commission.
But these provisions are put in for the purposes of ensuring that a party who has entered into a polygamous marriage is able to apply for a decree of nullity and, consequent on that, obtain financial remedy. That's the focus of these amendments or these changes.
Well, yes, but not in relation to Section 11D as it became, because as it was originally introduced, it was intended to reflect the law of validity and domicile in respect of polygamous marriages, and to encompass within it a potentially polygamous marriage. And the reason that I say this matters... Sorry, my lord.
Exactly. Because
yes,
under the previous general common law, a potentially polygamous marriage was not recognised for any purpose, can we just say?
yes,
But particularly it wasn't recognised for the purposes of entitling a party to claim a spouse, to claim a financial remedy. So this was included to ensure that somebody in that situation would be entitled to apply for a decree and obtain financial relief.
yes. But in so doing, and so in enabling Section 47, enabling that to occur, it set out the consequences of a person entering into a marriage in a potentially polygamous form as being void. And the consequence of that was that it wasn't... The fact that it was void,
yes,
the fact that it was void didn't preclude an application for matrimonial relief. That's what Section 47 did. And I appreciate entirely what your Lordship is saying to me, but what I'm trying to get at, and I accept that, is that in reflecting that legal position as it was at the time, and in line with what we saw in the 1971 report, which was that no change to validity itself was intended, the circumstances in which a potentially polygamous marriage would be void for somebody domiciled here, that is relevant to understanding what marriages were in the contemplation of Parliament at that time. It's a further point of context. So when I was taking the court through the 1971 report and looking at the kinds of marriages which were intended to be included in social security provisions, it's further relevant that the Law Commission and the changes to the void provisions reflected the fact that a person entering into a polygamous marriage or potentially polygamous marriage would have always been void. So if one's putting oneself back in the shoes, as it were, of those using the words as they did at the time, they were never envisaging that a person domiciled here would lawfully, under English law, be entitled to enter into potentially polygamous marriage.
Section 11B says that a marriage that takes place after the commencement of this act shall be void. on the ground that at the time of the marriage either party was already lawfully married. But does that apply to marriages? Is that regardless of whether marriage is celebrated?
I just need to look at the provision to make sure I'm answering it correctly. My understanding of that was that it was supposed to apply to potentially otherwise bigamous marriages.
Anywhere.
Yes.
So on that basis, that if a second marriage would always be void.
But it depends on the basis on which it was entered into and where.
Yeah, but that's why I asked you what's the
Yes,
reach of that
sorry.
provision?
Well, I think that subsection D is dealing specifically with polygamous marriages, as opposed to.
Yes, but D is specifically polygamous marriages entered into outside England and Wales. But
Well, it must be intended to do something different from subsection B. Otherwise, it would have been no point.
There's a bit about this in Hussein, isn't there?
Yes.
what I was trying to work
Yes.
out
Yeah.
is you're saying that if the marriage is void under English law, then it's irrelevant for the purposes of a benefits claim because it's void.
Yes.
And if you're saying that the effect of section 11b is that any marriage entered into at a time when either party is already lawfully married is void, then and if that applies to regardless of where the marriage was celebrated, then
No, I was trying to say that my understanding of the way that the law progressed was that section 11D in its original form was intended to reflect that a marriage that was potentially polygamous would be void.
yes. So 11b only applies to marriages celebrated in England and Wales.
I appreciate that's the opposite answer to the one I gave a moment ago, and it may be that we've got there in the end. But unless that's right, subsection D wouldn't serve a separate purpose.
Right.
Yeah.
So B only applies to marriages celebrated, and D. So what we're talking about is the general position, which isn't covered by this. The capacity to marry is governed by the law of the antenuptial domicile of the parties.
Yes.
So
So it may not add much to my point about whether you start with the valid or not valid, but I suppose, sorry my lord, I interrupted.
No, it's all right. No.
It was, because it was a development of the law that was subsequently tweaked.
Yes.
Thought it
So
made
this is
sense
specifically dealing with the situation where you have it's not dealing with benefits at all.
No,
It's simply
not directly,
focused
no.
on we want to ensure, as they said in the working paper in the report, that somebody who's entered into a polygamous marriage outside England and Wales is able to make a claim for financial relief.
I don't think I can take.
So what I'm trying to actually work out is
what
does it have much to do with this case at all?
Well,
or are we looking at the conflicts, as my lord said, are we looking at the conflicts of laws
I think
provisions?
we are, but that is the same point, I suppose. It's the same point about conflict of laws and
But
validity.
I'm not sure this is
Going to help me much.
Well, I'm not sure this is the conflict of laws point section. That's why I was asking you of its reach.
I think I'll leave it there, my lord, because I don't think I'm going to make any progress on this point, frankly.
Sorry to ask.
No. I'll not at all. Right. So that was my section 11D point. I'll then just briefly draw together the points on construction. If I can find them. Sorry, bear with me, please. Yes. It's 5 brief points, and it's the same 5 brief points I made in opening, but I just make them to button them down so far as they go. Number 1, the reason why we say it's the correct construction. Number 1, it's clear from the context as to the mischief at which the provisions were aimed, and therefore the purpose was to address polygamous marriages entered into in a polygamous form when the parties had the capacity to do so, but had by the time of claim become monogamous, such as in cases of death and divorce of the first wife. Secondly, the context looming large that we have talked about in detail was the validity and domicile provisions, which were not intended in any way to change as a result of the Law Commission's materials and decisions. Thirdly, we say that the use of the word marriage and spouse, albeit specifically defined in the terms of polygamous marriages, is consistent with the words of the primary legislation in relation to benefits, sections 39A and 36, and the enabling power, which refers to marriage and spouse. Fourth, paragraph 61 of the Law Commission's report clearly identified the policy of not encouraging or permitting polygamous unions, polygamous marriages, sorry, I've been picked up on that before, polygamous marriages of those domiciled in the UK. And looking at it another way, otherwise, a person who has chosen to enter into a second marriage abroad, despite being already married under English law, is in a better position than a long-term cohabitant.
Can you say that again so I
Yes,
can note it down, please?
Otherwise, a person who has chosen to enter into a second marriage abroad, despite already being married under English law, is in a better position than a cohabitant in terms of bereavement payment. Because a person who's only cohabiting rather than married is not entitled to bereavement payment. And so we say the concept of validity under English law does arise as part of the necessary implication under the regulations. And the final point, number 5, is the settled practice point, which I've already developed just now. We say that is a further and final aid to construction which supports, and indeed is the origin of, the basis on which this case was determined. It's that consistent line of cases to which I took court. So those are our submissions on why we say that analysis and that construction is the correct one. there isn't don't think there's anything further specifically to add. Those are my points on that. So unless the court has any more questions on that, I shall move on to Article 14.
There was a wonderful bubble coming out of your head then.
Please don't ask me any more questions.
It was something like that, yes. Enough. Yes.
Thank you. I'm glad you can read my mind, lady. Article 14. Now, in a nutshell, the court will have read the Upper Tribunal's decision. We have effectively 3 grounds of appeal reasons why we say that the Upper Tribunal judge's decision was wrong on Article 14. Number 1, analogous position. Number 2, justification. And number 3, remedy. And I'm going to develop those each briefly in turn, by reference, insofar as I need to the skeleton argument, just to ensure that I can make some decent progress, and in light of the indication that the court perhaps doesn't need me to go through all the detail on that in the same way. The court has the evidence that we've seen from Ms. Walker on the policy issues. It also has the first witness statement of Miss Nassim, which is in the supplementary appeal bundle at tab 14. Now, perhaps may I just ask the court to turn that up very briefly so that I can identify that document for you, because it will inform some of the submissions I make on the grounds of appeal. So it's in the supplementary appeal bundle. Tab 14, page A98. Is the court with me? Now, what Ms. Nassim does is runs through the policy, and the key paragraphs for our purposes really start at paragraph 29 on page A104. And I won't ask the court to read it all now, but I'm just identifying this as the original justification, as it were. She explains at 27, 28 and 29 the basic policy that we've just been looking at, that valid polygamous marriages are recognised as a matter of comity, but there are limits on the rights and entitlements of second and subsequent spouses. And then paras 33 to 36 deal with validity again. And again, I don't think there's going to be anything in detail added to what we've already said. The passages that are particularly relevant, for example, to justification, are 47 to 56, which is headed justification. And there are a number of, as it were, legitimate aims which were relied on as justifying the difference in treatment insofar as it gets over the analogous position hurdle in this case. You have the concept of validity of marriage, the public policy against polygamy, and then over the page at paragraph 54, 53 and 54, she talks about administrative certainty and additional complexity. And one of the points I think taken against me is, well, it's and by the Upper Tribunal judge, well, it's already complex, and it would only be additional complexity. In my respectful submission, there is straightforward evidence about the particular difficulties that would arise if further investigations into the origins of the relevant marriage and so on and so forth were required, and that is a matter to which the court should accord a measure of respect. So it's not enough to say, oh, well, it's already complicated anyway. Paragraph 56 deals with the risk of further claims being made, and she says there would be stronger arguments, this is the third sentence, arguments that void or invalid marriages for reasons other than polygamy should be recognised across the contributory benefits system. So for the example I gave is reliance of cohabitants. The status of spouse for benefits law would come down to the say-so of the couple or surviving spouse, in all likelihood drawing the Secretary of State into greater and more varied questions about the validity of specific marriages. It's also possible that the reliance on a religious ceremony will raise wider equality issues in relation to other types of celebration, and so on. In that context, the Secretary of State and Parliament have chosen to draw a line regarding benefit payments to spouses of polygamous marriage as at an appropriate and proportionate place, which she means effectively based on the domicile validity issue. So that's the evidence that was before the Upper Tribunal. And then I can just move on briefly to make my submissions on analogous position. The court's got my submissions on analogous position in the first skeleton argument at paragraphs 40 through to 46. I won't go through them all now, but what I propose to do is just to encapsulate for the court why we say that the judge was wrong to find that there was a sufficient analogue here. The judge found that Mrs. Akhtar was in an analogous position to a lawful widow, a widow who was validly married under the law of England, UK. We say there is an obvious and relevant difference between the two groups, which means that they are not properly analogous. One, under English law, is married, and the other is not. The other marriage does not comply with the legal requirements for being recognised as a lawful marriage. And so, in a nutshell, our submission on analogous position is as simple as that. The courts have accepted over various different cases, and I'll refer you to McLaughlin, which is I think perhaps the clearest example of that policy of legal marriage is a clear line which represents a set of legal rights that flow from a public contract. And that, therefore, if you are distinguishing between those who are treated as legally married and those who are not, in truth, who are cohabitants for the purposes of English law, there is a straightforward, obvious and relevant difference in treatment. And for the sake of speed, can I just tell the court the reason why we say that's a good point by reference to McLaughlin. In McLaughlin, the Supreme Court was dealing, this is tab 12 of the main authorities, the Supreme Court was dealing with widowed parents' allowance under the Northern Irish provisions because of the children who were the beneficiaries of the widowed parents' allowance. Bereavement payment stopped at the High Court stage. Mr. Justice Tracy in the Northern Irish High Court, and that's at tab 11 of the authorities bundle. And you find his encapsulated reasoning at 66 to 67 of that judgment.
Hang on 1 second.
Yeah, and I think...
Hang on 1 second.
Yeah. Perhaps we just turn it up because I think it's a short way of dealing with the point. Tab 11 of the main authorities of the court, which is so kind. And it's the last page of the report. Last page of tab 11, bottom of the page, paragraph 66. So it's the penultimate page, but the last double-sided page. You see So para 66.
Yep.
Through marriage or civil partnership, the couple regulates their relationship with each other. The couple puts the state on notice of their relationship. A cohabiting couple makes no such public contract. This is in itself usually sufficient to make the two relationships sufficiently different in a material particular to lawfully treat the relationships different. By act of marriage, the couple opt in. The treatment arises not by virtue of the quality of the relationship, but because the couple have made the contract and made the state aware of their changed circumstances. So it's that point. And it's for that reason that the court found that the bereavement payment claim failed. And in the Supreme Court, if you turn over to tab 12, you'll see that Baroness Hale, albeit obiter because that issue didn't reach her on the appeal, at paragraph 26 on page 226, bottom page numbering 226, so Baroness Hale was dealing with the widowed parents allowance issue. At paragraph 26, she says it's always necessary to look at the question of comparability in the context of the measure in question. Middle of that paragraph, just between G and H. It was for this reason that Tracy James, Justice Tracy, was able to distinguish between the claim for bereavement payment and her claim for widowed parents allowance. In the case of the former, he held the public contract and meant her situation was not comparable. 66 to 67, the passage I've just taken the court to, that decision has not been appealed. In the latter case, he held the relevant facet of the relationship was not their public commitment, but the co-raising of children. That's the widowed parents allowance. For that purpose, marriage and cohabitation were analogous. In my view, that analysis is correct, paragraph 27. So we say that is the simple reason why there is an obvious and relevant difference. Now, just for that wording, so the court can, I'm sure the court's very familiar with it, but if you look back over to paragraph 24 of Baroness Hale's judgment, under the little heading, analogous situation, she cites the famous passage of Lord Nichols in Carson. The essential question is whether the alleged discrimination can withstand scrutiny. There may be such an obvious relevant difference. So that's where I get that wording from. So we say, in simple terms, if the court is with us on the construction issue, it follows that there is a straightforward difference between the status of a lawful marriage and one which, as at English law, takes effect only as cohabitation, and that's the beginning and end of that point. Upper Tribunal Judge Whiteley referred to the paragraph but didn't grapple with that principle in his reasoning. And so we say that you should allow the appeal on that ground.
Is a person to whom the regulations apply a party to a valid marriage under English law?
Well, it depends on how you construe regulations. Obviously, I'm only making these submissions in the event that I persuade you on the construction issue. If you'll find that the construction includes a person who includes Mrs. Akhtar, then...
No, I understand that.
Yes.
But so your submission
void.
is it can never apply, because it never applies to somebody who has not contracted a valid English marriage. That is the clear line.
Yes.
Yep.
It's the line
Yep.
of validity and domicile, and
Yep.
it's as simple as that, really. So...
Well, yes, absolutely. The line is validity. On the facts of this case, validity is determined by domicile. But to call it validity and domicile is not really the essence of your analogous point.
No, it's the lawfulness of the marriage, yes.
Exactly.
So I think for present purposes, that's the straightforward analogous position.
Yeah.
On ground 2, justification, again, you have the submissions in detail in the skeleton argument. We take them in stages. At paras 47 through to 60.
So sorry, I was just looking at something. Where
Sorry,
are we going?
Skeleton argument, first skeleton argument,
Yep.
paras 47 through to 60.
Yep.
They deal with the justification argument. Now, without going through all of that in detail, if I can just make a few crisp points as to why we say the judge failed to apply in substance the right test, and why, if this court applies it correctly, it should find in our favour. It's those several points. On a review of a first instance decision on proportionality, I accept that I must show that the judge below got it wrong, rather than just simply that this court must undertake the exercise itself. And if authority for that proposition is needed, it's decision of this court in TP and AR, tab 24 of the supplementary bundle of authorities. No, main bundle of authorities. Sorry, forgive me. Can someone just find me the reference to TP and AR, please?
It is 24 in the main.
Ah, it is.
I think this is the point on which Lord Sales has recently opined extrajudicially, saying that the Court of Appeal has tied itself too narrowly. But
So be it.
there we are
now.
for the moment.
So I suppose it's a point in a way against me, because I need to say to this court, even though the judge has undertaken the exercise for himself, this court needs to be satisfied that it was wrong before it can intervene. I say there's a simple reason why he was wrong,
Yeah.
which is that he simply applied the wrong test in substance. Although he cited the manifesto without reasonable foundation test, which is, in a nutshell, a hands-off respect to the decision maker, policy is not for the court, if I can paraphrase in that way. What he did was a forensic step-by-step disagreement with each policy reason given. And that, in my respectful submission, is not the proper application of the manifesting without reasonable foundation test. Look at the issues in combination. He went through each and every legitimate aim and said, I'm not persuaded by this one, I disagree with this one. For example, on administrative convenience, I don't agree that it's administratively more difficult. And in my respectful submission, that's enough for this court to say that the test was not properly applied in substance. And it's for that reason that we asked the court to accept that this was a case where there were a number of different legitimate aims put forward. The policy, the administrative difficulty, the straightforward bright line between a lawful marriage and one that is not treated as lawful under English law. Those same points under analogous come in at the decision, at the justification stage.
Yeah.
But there were a group of legitimate policy reasons encapsulating the line that the Secretary of State had drawn, Parliament has drawn, and they plainly provided a reasonable foundation for the difference in treatment. Albeit on the facts of the case, and we've always accepted this, on the facts of the case, it's a hard case. But we know from a number of cases, RJM and animal defenders and so on, that all a line is a beneficial, bright line.
Well, it's a hard case of a kind which occurs in all sorts of circumstances. The only thing that makes it hard is that the parties thought the law was something different from what it was.
Indeed. Which is why when I said in an opening that it was a situation where no one was being critical of anybody, but it could have been regularised but wasn't. The law is, in that respect, clear as to what, under English law, has to happen in order to have a valid marriage. Subject to the polygamous issue, of course, but on this analysis we're looking at it from a straightforward, the construction is what it is, premise. And in order to make that point good, the court to the crispest example of that, which is in a speech of Lord Newburger, with which the court will be familiar, in RJM. And it's tab 8 of the main authorities, paragraphs 54 to 57. This was a case about benefits income support and disability premium, so a similar sort of context, welfare benefits, where benefit was not paid to a person if they were without accommodation, a homeless person, in the case of Mr. RJN. And in relation to discrimination and the justification, Lord Newberger, at paragraph 54, policy concerned with social welfare payments must inevitably be something of a blunt instrument, and social policy is an area where a wide margin of appreciation is accorded, and that's the judgment in STEC. And then I referred to Animal Defenders International. A general rule means that a line must be drawn, and it's for Parliament to decide where, and this inevitably means that hard cases will arise falling on either side of it, but that does not invalidate the rule if judged in the rounds it's beneficial. And then picking it up at para 57, perhaps, the fact that there are grounds for criticising or disagreeing with these views, namely the views encapsulated in the previous paragraph, does not mean that they must be rejected. Equally, the fact that the line may have been drawn imperfectly does not mean that the policy cannot be justified. Of course, there will come a point where the justification for a policy is so weak, or the line is drawn in such an arbitrary position, that even with the broad margin of appreciation, the policy is unjustifiable. However, this is not such a case. And in my opinion, it's the same point here. Once one starts from the premise that there were a package of factors that mitigate in favour of the policy, combination of the policy reasons, the administrative complexity reasons, and so on, it wasn't for this Upper Tribunal nor for this court to disagree and second guess, even if it might have drawn the line in a different position, because the line was clear and broadly beneficial. So in respect of justification, those are my submissions for the more detailed reasons set out in paragraphs 47 through to 60 of the skeleton. And I think perhaps at this point in the day it won't do any good to go through them in any more detail on that.
I should have said earlier, I was about to say both skeletons, all four skeletons were very good. So we know where we stand and where you stand.
Thank you, Mike. On remedy, that's the final point. I think the point is again a brief one that flows from the points made in the skeleton. If the grain of the legislation is as we have articulated it in our construction, then it follows that reading down under Section 3 of the Human Rights Act is not the appropriate course, because it has potentially quite significant for the way in which marriages which are otherwise void are to be treated.
Well, there's a lot of loose down. We would only read down for this situation.
Yes.
It doesn't mean that we'd redraft the relevant.
No, but by definition, sorry, Mike.
No. Well, perhaps I haven't thought this through.
By definition,
4
it's
o'clock.
not a case where it's particular facts, for the reason my Lord Justice Moylan put to me earlier on. If you have if what you're doing is effectively saying that the words otherwise valid under English law don't apply, or that then that's the effect of the reading down. It would include any polygamous marriage which was in fact monogamous, regardless of the basis on which it was entered into and where. And it's otherwise.
But is that? I mean, I'm sorry, I didn't let you develop your submission. But why would that be so terrible?
Well, because we say it would go against the grain both of the regulations and the enabling provisions, but also Section 11D of the Matrimonial Clauses Act 1973, which we have rehearsed. But I think.
Well, would it? I mean, would it affect Section 11D at all? I think, as I say, I hadn't let you made your point, but I thought that was where you were going. And surely all it would affect is the regs. And in fact, isn't there a point here? Forgive me if this is another 4 o'clock point. This is not primary legislation.
No.
It, 'cause- 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 'cause-
it's obviously a different situation to, in McLaughlin, the reading down that was asked for in that case. In McLaughlin, the Supreme Court found that it couldn't read down the primary legislation to include cohabitant in the word spouse. And we have subsequent decision of the Upper Tribunal finding the same principle for the primary legislation in relation to a religious marriage, case of AR. We haven't got a case on the secondary legislation. So just give you the reference for AR, it's tab 17 of the main authorities. So
Yes, I'm sorry. Forgive me if I'm muddling you, but
we are,
Section 4, which is what we would be in if we weren't in Section 3, is only about a provision of primary legislation. You can't make a declaration that the regs are incompatible, can you?
well, you could grant declaratory relief. Is that right? I'm just.
No,
I think you can make a declaration.
you can. You're quite right.
I'm glad I hesitated at least.
No. I was just testing you.
Sorry. Tab 4 of the main authorities bundle.
Yes. That's
I accept the premise that reading down primary legislation.
No, it simply provides differently for primary and secondary. Forget what I said. And keep going.
Yes. The Supreme Court has said the appropriate relief in relation to the word spouse in the primary legislation is a declaration of incompatibility. The Upper Tribunal in AR, tab 17, has said that the declaration, not a reading down, is appropriate for a religious marriage which is not otherwise a marriage, albeit there was no polygamous issue there, so it's not really of direct relevance. But the on when you are a spouse and when something is a marriage is clear, at least under the primary legislation. And it's for that reason that we say simply reading down the secondary legislation would potentially introduce an anomaly into that statutory scheme for the reasons that are set out in more detail in our skeleton at 61 to 65. So although it wouldn't itself amend the primary legislation, it would have the effect of creating, we say, something that does go against the grain. In the words of Guy Dunham Mendoza, Lord Nichols. It's a short point, really. The Upper Tribunal considered that it was appropriate to read down, and we say it wasn't. So those are my points on remedy. I've left Ms. Rooney no time, I think, but it's a matter for this the court to, whether she might want to start or not. I'm not sure.
Well, it's only 4 o'clock.
Well, I'm never quite sure when the court wants to stop or not.
Well,
particularly after the day it's had. But I shall sit
No,
down.
I'm afraid we're all for powering on to a convenient time between 4:15 and 4:30, which may well be 4:30.
I'm very happy for that, and I think I may have had some advance
Do
warning to that
either
effect, I'm hopeful.
my lord or my lady have any further questions for? No, it looks as though you're all right.
Thank you.
Yes, Ms. Ring.
My lords, my lady, I'm very grateful to Miss Leventhal, who has done, I think, a lot of the heavy lifting. I think you're absolutely right in respect of the legislative history and also the excellent legislation that's in force. As a result, I do hope that your estimate is correct and that we can be done by lunchtime tomorrow. That may depend on how many questions my submissions provoke, but I'll do my best certainly to stick to that time limit. By way of brief introduction, as my lords has identified, there are 2 skeletons from each party in this case. One is in respect of a matter of construction under the ordinary principles, and one is in respect of an Article 14 argument under the European Convention on Human Rights. The more recent point is about, as say, the legislative history and issue of construction that was raised actually by the bench. We're very grateful for the fact that issue has been brought to our attention effectively, the way these proceedings have maybe not been entirely orthodox. But what I think is certainly clear is that actually there is a real minefield of information in this area. And I raise that now because actually it is relevant to some of the issues that we're going to come on to look at, not least the importance of prior practice of, for example, the commissioners below. There's a genuine and I think legitimate question to be asked as to how many times the courts have ever actually properly considered the wealth of material that is before the court today. And we ask you to bear that in mind when considering issues such as the importance of prior practice, prior decisions effectively in this case. I intend to address you today on 8 topics. I'm afraid they're alarmingly similar to my learned friend. I intend to start with a very brief summary of the facts. I don't intend to repeat what Ms. Leventhal has done. Her summary of the facts are accurate, but there are important nuances that we say are important to the outcome of this case, and in particular the Article 14 point. Secondly, I'd like to address you on a number of construction points. I think they can be taken shortly. I don't think they're in dispute, and I say that with some confidence, as I think it was my skeleton that was cited for those points this morning. But there are just points of emphasis that I think are particularly important, not least in circumstances where this morning and today there's been a lot of discussion about necessary implication. So it's just going back to basics and reaffirming those principles. The third topic that I would like to address you on is the extant legislation. I don't propose to go through it again in depth, but there are a few points again, as I say, of emphasis that I would like to draw the court's attention to. That, I expect, is where I might get to by 4:30 today, which will leave then for tomorrow the real sort of meat of the topic, which is the legislative history and its significance. In that respect, and I don't say this as criticism, there's a lot of material. Ms. Leventhal's taken you to some, but we say not all of the relevant materials. And most importantly, in that respect, we highlight the 1968 report, which predated the 1971 report, and we say is actually where a lot of the more candid reasoning in respect is. I'll then address you. My 5th point is on effectively our submissions on the construction point, before turning to the Article 14 arguments. And grounds 6 to 8, 6, 7 and 8 are all in Article 14. Point 6 is just a quick summary of the law and legal principles. Point 7 is in respect of the remedies that this court can address. And point 8 is about how we actually apply the law and the principles on remedy in this case. Before turning to my first issue, I'd be grateful just to take a moment to talk about what this case is and isn't about. In that respect, we think it's really important just to put down effectively a marker. This is not a case about the endorsement of polygamy. The court is not being asked to do that. It's not what the effect will be. And we'll see in the documents that is also not the effect of reading down any of these the relevant legislation compatibly under Article 14 or giving it its proper construction under the ordinary principles. Mrs. Akhtar, as we'll see, is in an inadvertently polygamous marriage. It's entirely a mistake, and she doesn't appear, I don't appear here today on her behalf in any respect as an endorsement of polygamy. The second thing that we note is that despite what we've heard, I think, from my learned friend, this is not a case that shakes the institution, the roots of the institution of marriage to its core. This is about interpretation of an incredibly discrete bit of secondary legislation, the 1975 regulations, and as my Lord Justice Moylan quite correctly identified, actually, really, when you get down to the bones of this case, the 1973 Act effectively is of little to no relevance. We don't dispute the principles on legal validity. We don't dispute when a marriage will be, and we don't dispute that Mrs. Akhtar's marriage is void. But we are looking at a discrete bit of secondary legislation, which, and this for us is an important point, is a deeming provision. It's a deeming provision for very specific purposes. Effectively, what it does is it says, irrespective of the status of your marriage under the 1973 Act, frankly, that is not relevant for these limited purposes, because for these limited purposes, we are going to treat you as if you are married, as if you are a spouse. That's the whole purpose of the 1975 regulations, their deeming provisions. And in those circumstances, we say it just isn't arguable to suggest that it does any violence to the underlying concept of marriage in the 1973 Act. No one says that Mrs. Akhtar is married. No one says that it will change the status of her marriage. They just say for limited, discrete purposes, she should be treated in the same way as a married couple. That's a policy decision reflected in legislation, and it's an entirely proper one. Finally, two points by way of introduction. We do note, just for, I suppose for the record, this is not a fact-heavy case, but we do note that the genuine vulnerability of Mrs. Akhtar's position, there is, we say, real unfairness arising as a result of this case, and it's something we'll return to in the context of the Article 14 arguments. But this is a case where no one disputes that Mr. Akhtar paid national insurance contributions for his entire life, that he made the relevant threshold. It's also a case where no one disputes that for the entire time that they have lived in the UK, or that they lived in the UK together, they lived as if man and wife. And in that respect, it's important to note that when Mrs. Akhtar arrived in the United Kingdom, Mr. Akhtar had already obtained a valid UK divorce from Mrs. Beebe. The entire time that they have been living in the UK, they have been living effectively as a married couple. And a huge distinguishing feature from a lot of the cases that we've seen, my lady has already picked it up, is that actually this is a rare case where we have only one sole surviving spouse. And that is a distinguishing feature. It's particularly relevant
I don't criticise you for making all these, if I may say so, merits points, but it is actually important to know whether they really do feed into the legal analysis. How can it make a difference that...
At the Article 14 justification stage is where we say. So I entirely accept these are jury points, and they are jury points that are for the purpose of a construction argument. They don't feed into construction under ground one when we're just looking at the ordinary construction, and they don't feed into the first couple of stages, analogous position, etc. for Article 14, but they must be relevant to justification because there is, as we say, unfairness. And that brings me to the last point by way of introduction, which is just about the nature of the Article 14 claim. It's been dealt with very briefly by my learned friend, and I'm sure that's because it's been dealt with at length in written submissions. But we say it is important to note that this is not an afterthought in Mrs. Akhtar's claim. It was front and centre of her original claim. And in particular, it's also front and centre of the decision of the judge below. And despite the very eloquent summary that my learned friend has given, this is not a simple case of valid and not valid. That would of course be a bright line distinction, but my learned friend makes the same mistake as the people who she represents, which is to fail to appreciate the significance of the fact that Mrs. Akhtar was not just in a polygamous marriage, she was in a religious marriage, and that is a status recognised as an other status for the purpose of Article 14 of the Convention. So when we move into the Article 14 ground, we actually move very much away from polygamy. We aren't just looking at valid and invalid. We're looking at a religious marriage. There's a body of case law, and it is important that this court effectively gets its teeth into that as it has the first issue of construction. Subject to those points, I'll begin on my first ground, which is, or my first point, which is just the facts of this dispute. And I plan to take it very quickly, which is by reference to my first skeleton, which is in the core bundle at tab 3.
I've got it loose, so if you wouldn't mind just giving paragraph numbers as well as any page references you may give.
Thank you, my lord. The relevant paragraph number is, it begins at paragraph 5. Quite a bit of it goes on to paragraph 13. You don't need to read the entirety of that, much of it's procedural. But we do say that there are a number of important facts just to bring out, which is, firstly, we are looking at marriages originally celebrated in Pakistan on the 1st of July 1976. Thereafter, Mr. Akhtar moves to the United Kingdom by himself to join his parents. He's joined shortly afterwards by Mrs. Bibi, and given the similarity in the dates of their arrival in the UK, as I say, we definitely don't take a point in respect of Miss Bibi's domicile. I think we assume that she is domiciled in the UK, albeit that I don't think there are facts on that issue before the court.
I'm sorry to interrupt you about this. Not a point I've raised to my lord and my lady. They may know the answer straight away. You're reading out, and all the skeletons use their full names, but I see it's been anonymised in the title, at least as appears on the skeletons. This isn't an case that requires anonymisation, is it?
No, I think it was Judge Wakely, Upper Tribunal Judge Wakely, anonymised it in his decision, but it wasn't made at the request of any of the parties, and we're not, I think, distressed by the use of names. I can double check the point with my client, but I can't see that there would be any basis for anonymisation.
No, that's fine, thank you. I'm so sorry.
Thank you, my lord.
You go on.
It was in and around 2001 that Mr. Akhtar purported to divorce Ms. Bibi by talaq, so under Islamic law. And from that point, so from 2001, Mrs. Akhtar and Mr. Akhtar and Ms. Bibi didn't reside together. They were residing in different households and effectively living separate lives. And that's before Mr. Akhtar has actually met the current Mrs. Akhtar. Believing he had divorced Mrs. Bibi, he went back to Pakistan, and on 28th of November 2008 married Mrs. Akhtar. As I say, that marriage was also celebrated in Pakistan. It was at that point that he effectively received the advice he should have received effectively in 2001, which was that an Islamic talaq wasn't valid for UK law purposes, and that he would have to seek, therefore, a legal divorce effectively in the UK, which he did. It's from at that point.
Yes, I mean, it's we are where we are. It's odd that he's advised that he hasn't got divorced, and yet nobody draws what even to a non-lawyer might be the conclusion. Well, then what about my marriage while I was still not divorced? But there we are.
It's a truly terrible set of facts in terms of there are multiple stages at which one would hope that this would have gone better than it has. But
no, I agree. We are where we are. Yeah.
The important point, I think, for our purposes is that divorce was finalised before Mrs. Akhtar actually came to the UK. And Mrs. Akhtar was granted entry to the UK as a spouse. So she was granted entry clearance as a spouse under UK immigration laws. And it was on the 13th of November, having obtained that UK decree of an absolute divorce, as I say, that Mrs. Akhtar came to the UK. At all times from that point until Mr. Akhtar's death, Mrs. Akhtar and Mr. Akhtar lived together effectively monogamously. So at all times since they've been in the UK together, they've been living in fact monogamously. And for a period of that, of course, that is not just in terms of only one couple in one household. It's for a period of time there is only one spouse, because Ms. Bibi passed away before Mr. Akhtar. So she's been the sole surviving spouse, or the sole surviving heir, effectively, to Mr. Akhtar's any entitlement for a lengthy period of time.
But so far as Miss Bibi was concerned, for our purposes, she ceased to be a wife upon the English divorce proceedings being completed, which was November 2009. So even before her death, she moves out of the picture, as it were.
I think that's absolutely right. And the only difference that I could see, my lady, as to would be a practical one, not a legal one, in terms of some sort of unjustified competing claim from a divorced but living spouse. But otherwise, I can't see that there's any material difference between a divorced or dead spouse, without wishing to sound insensitive.
Well, whatever conclusion members of the court come to about what spouse means, at the time of divorce, English law did not recognise Mrs. Beebe as a spouse.
I agree, my lady. She wasn't recognised as a spouse. And from the point of which there were two spouses, so her marriage was not a valid one, as recognised by English law. She, from the point of a divorce, was divorced under UK law, albeit that not a spouse in the first instance. And then obviously from her death, she can't be relevant to this claim or to Mrs. Akhtar's position. So there are three potential points at which, or three potential stages to Mrs. Beebe's involvement in.
Well, I'm not quite sure about your first one, but I don't think you need to go there, because it depends on what domicile Mr. Akhtar had at the time he married Miss Beebe. But as I say, that goes too far in the past. But at the time of divorce, she was no longer a spouse, so far as English law was concerned, from the 13th November.
I think you're quite right that she, and apologies, that the likelihood is that they would have been domiciled at the point of their marriage in 1976. Thereafter, and I'm afraid I don't know the answer to this point, I don't know what happens to the legality of that first marriage as viewed under the eyes of Pakistani law when he takes a second wife. I understand he's permitted to have two wives under the Pakistani law.
Well, it depends on how Pakistani law regards the talaq, which was pronounced in 2001. So I don't think you need to go back that far. I'm just picking you up on something that you suggested we might be interested in. I don't think it counts, as it were.
I'm grateful, and I suspect I can't assist the court with that point, unfortunately. That then brings us to what I hope will be very brief construction points, which I think might take us up to 4:30 and might be a natural conclusion for today. And these are, I'd like to make a number of short submissions on two construction points. The first is the law on necessary implication. And as I say, I fear I'll be teaching my grandmothers to suck eggs in that respect, but I do think it's important to go back to the basics just to make sure it's absolutely clear, given the potential significance of that in this case. And the second, as I say, is about the relevance of repeated practice, effectively, of the courts, so repeated previous decisions. If I could ask the court to take up the supplementary authority bundle. The starting point is tab 21, which is a case called A minor. I'll just give you the references very briefly for your notes.
Which tab, please?
Tab 21 of the supplementary authority bundle. And this is a decision of the House of Lords, a case called B A minor versus Director of Public Prosecutions. And the relevant passage is from Lord Hutton on page 481. That's internal page 481, or I think there's a 316 at the bottom.
Yes, thank you.
And you'll see it's been sidelined. It's the last paragraph on page 316, and the second sentence in that paragraph. But the test is not whether it is a reasonable implication that the statute rules out mens rea as a constituent part of a crime. The test is whether it is a necessary implication. So making the point that I'm sure you already have, which is it's necessary, not reasonable. Moving then just one tab ahead, this is still the leading authority, is tab 22, which is Morgan Grenfell. And in particular, the dictum from Lord Hobhouse at paragraph 45, which is on page at the bottom. Page number at the bottom of the page is 372. Until very recently, this was effectively the final word on necessary implication, but it said it's accepted that the statute does not contain any express words that abrogate, in this case, the taxpayer's common law right to rely upon legal professional privilege in that case. And then this is the key line. A necessary implication is not the same as a reasonable implication. That's the point from B, A minor. And then thereafter, a necessary implication is one which necessarily follows from the express provisions of the statute, construed in their context. And we say that matters because, as my lord and lady have correctly identified, and I think, as is now conceded, there aren't words in the relevant legislation in this case that would give rise to the necessary implication which the Secretary of State seeks to draw. And therefore, this is a case of necessity.
I don't know why it's been put entirely as necessary implication. If we say that the natural meaning of marriage in the context, or the word spouse in the context, is lawful marriage, and we simply say that's by English law, because after all it's an English statute, why isn't that a legitimate piece of construction?
Well, I think this would come back to the point that my Lord Justice Moylan raised, which is about exactly the sort of words that you would have to read in, which is that it isn't just enough to read in.
Well, you see, it's been talking about reading in, as it were, tilts the question your way. But one's constantly looking at words in statutes and saying, do I give this a narrow meaning or a wide meaning? And one doesn't normally test that by necessary implication. You simply say, I'm looking at the word marriage in section 36 or section 39A or in the regs. And in its context, does this mean a marriage that is lawful as a matter of English law? And certainly, it would be very difficult to say it doesn't mean a lawful marriage. I mean, the natural meaning of a marriage is a marriage which is effective in law. I agree there's then a further question, which law? But it's not really a matter of implication to say English law rather than some other law. It's a question of ordinary interpretation.
So I think my primary submission in response would be that we will get home one way or another, which is that we would be right even if it was just an interpretation of the word marriage for the reasons we've come on to look at from the legislative history. I do say that necessary implication would be the more appropriate approach to construction in this case. And that isn't because I accept the point entirely that if you were just construing an ordinary statute and came across the word marriage, that it may well be appropriate just to say, well, what does the word marriage mean, rather than trying to read in a necessary implication. The problem, I think, with that is that we're reading the word marriage in the context of the 1975 regulations. You're reading it in a context that actually suggests a much more complex idea of marriage. So that will be something, obviously, that I will have to take you to in due course when I look at the extant legislation. But we say this is not just like reading, for example, Section 11D under the 1973 Act, or even actually the primary legislative provisions in the 1992 Act, i.e. the legislation that gives rise to bereavement payment and widows WPA. And the reason we say that is that those are statutes where actually you'd be looking at the word, you'd be saying, well, what does spouse mean? But this is a regulation that is effectively all about different types of marriage. It's about polygamous marriage, it's about monogamous marriage, it's about actually monogamous marriage. And in those circumstances, it places a huge amount of weight on the word marriage just to say, well, okay, I'm going to interpret that as lawful marriage without looking to some extent at, is that actually necessary in the context of the legislation? I'm happy to address you on the basis that either of those legislative techniques is appropriate, and we say in any event, necessary implication or not, we would get home on the definition of marriage.
Hang on 1 second. Right, well, I took you slightly off your course, but would that be a natural place to break? Or?
Can I take you to one further case, and then it's only to
If
take
you like, you can.
to give you the reference, and then that will.
Yes.
I'll stop there. It's one that my learned friend has taken you to anyway, but it's just to put it in the context of the earlier cases, which is R Black versus Justice Secretary, which is tab 28 of the Supplementary Authority bundle. And this is the judgment of Baroness Hale, and the relevant paragraph is paragraph 36. And it's a point against me, which is that Baroness Hale effectively recognises that she is modifying the test in Morgan Grenfell. So effectively, Morgan Grenfell said when you're determining a necessary implication, you look at it has to come from the express words. There must be express words, and then it says express words in context. And what Baroness Hale effectively does is, I think, divorce those two elements so that you're looking at express words and context. And in due course, my submission won't be any higher in this respect, then nonetheless express words remain important, and there are no express words to support the interpretation run by the Secretary of State in this case. And if it pleases your Lordships and Ladyship, that is a convenient point of view.
It is. One moment. Very well. We'll 10:30 tomorrow. Thank you very much indeed.